In today's new norm, so much is being done virtually and online. In terms of procedural hearings, having it virtual or by way of video conference or even by way of teleconference is a very, very common situation. And this is something that most parties would be used to, because at the end of the day, this is like a planning type of meeting. Usually there's not heavy arguments, and certainly there are no witnesses. However, it is now increasingly common that even witness examination is done by way of video conference. In the past, it wasn't unheard of. It could be that, let's say, most witnesses are available in Jakarta, but you have one witness who is, for example, an expert, and he is based, to give an example, in Norway. And the parties agree that that witness will be giving his evidence by way of video conference.
So, having looked at certain types of limitations, let's now come back to party autonomy itself and how we see this widely spread across what is international practice and by way of international standards. So, coming back to the UNCITRAL model law, we saw some examples of certain jurisdictions that did incorporate Article 19 or something along the lines of Article 19 of the model law, which contains this party autonomy principle. But in fact, what you see is that the UNCITRAL model law itself has been so widely accepted and incorporated that as a result, what follows is that party autonomy has become an internationally accepted principle. And what it says is that the legislation based on the model law has actually been adopted in 83 states and a total of 116 jurisdictions.
There is no magic or optimal number for all arbitrations. However, there is consensus on some do's and don'ts. Firstly, avoid even numbers, for example, 2 arbitrators. Secondly, avoid numbers greater than 3, otherwise it will be cumbersome and uncertain. Thirdly, the most common choice is either 1 or 3 arbitrators, and the main questions are A, whether the parties can indeed agree on a single person, and B, whether the nearly triple costs of 3 arbitrators can indeed improve the quality, efficiency, or diversity of the arbitration.